Hi, Assalamualaikum. I'm Julea.
And I'm Alia. So today we are going to present two subtopics from the law of contract,
Which it is discharge of contract
and remedies. Let's call Julia first to present her topic.
What is discharge of contract? Discharge of contract happens when parties to the contract are released from any obligation arises under the contract. A contract creates certain obligation on one or all parties involved. The discharge of a contract happens when this obligation comes to an end. There are many ways in which a contract is discharged, but today I want to focus on 4 types of discharge. Discharge by performance, discharge by agreement, discharge by breach, and the last one, discharge by frustration. Discharge by performance, when the party to a contract fulfill the obligation arising under the contract within the time and manner prescribed. Then the contract is discharged by performance. Discharge by performance is the most common way to discharge the contract. For example, Alia offered to sell her handbag to Ahmad for Rm 1000. If Alia give Ahmad the handbag and Ahmad give Alia Rm 1000, in this situation, the contract is said to be discharged by performance. The performance of an obligation must be done strictly in accordance with the term of the contract, unless otherwise agreed. There are 7 types of discharge under discharge of performance: time of performance, place of performance, reciprocal promises, contingent contract, standard of performance, percentage performance, and the last one, joint agreement. Discharge by agreement. If all parties to a contract mutually agree to replace the contract with a new one, or annul, or remit or alter it, then it leads to a discharge of the original contract due to mutual agreement. A contract can be discharged if the party agree that the contract will be discharged. For example, Amira entered into a contract with Farah. In the contract, both agree that the contract will be discharged if the profit of the business is less than 500,000 in a year. If the profit is less, then the contract is said to be discharged by agreement. This type of discharge is applicable under Section 63 and Section 64 of the Contract Act 1950. Section 63 defines that if the party to a contract agree to substitute a new contract for it, or to rescind or alter it, the original contract needs not be performed. Section 63 of the Contract Act 1950 provides that the party can agree either to substitute an existing contract with a new one, or rescind the original contract, or alter the original contract. Section 64 defines that every promisee may be dispensed with or remit, wholly or in part, the performance of the promisee made to him, or may extend the time for such performance, or may accept instead of it any satisfaction which he thinks fit. The application of dispensation or remission of performance provided under Section 64 can be seen under the following situation. Number 1, the payment of a lesser sum to satisfy the whole debt. Number 2, payment of lesser sum by third party to satisfy a larger debt. Number 3, payment in satisfaction of some of an ascertained sum. And the last one, an agreement for settlement of debt between a debtor and his creditor. Discharge by breach. If a party to a contract fails to perform his obligation according to the time or place specified, then he is said to have committed a breach of contract. When party is in breach of contract, the other party to the contract has right to rescind the contract and claim damages from the breach. A breach may occur because of the refusal to perform and disability to perform. Refusal to perform means where one party informs the other by conduct or word that he does not want to go on with the contract. Disability to perform means if one of the party disabled to perform, the contract is automatically breached. In Cho In-Lu versus Visuvaligam Pillay cases, court allow a contract to be rescinded when an employer failed to pay wages 1 in every 2 weeks as promised. A breach may be made expressly or impliedly from one's product. Anticipatory breach occurs when one party indicates before the time of performance, due either that he does not intend to perform or that he intends performance different from the set out in the contract. The innocent party can either repudiate their contractual obligation as soon as the other party indicates their refusal to perform, or wait for the performance date and hope that the other party performs their duties. Actual breach occurs when performance is due on or in the course of performance. It can either be failure to tender any form of performance inadequate. The effect of an actual breach is that where the innocent part terminates the contract, he must restore and return any benefit received from other party. The innocent party can either continue with the contract and claim damage or repudiate the contract. Discharge by frustration. Terminate if the thing that party agreed to do is impossible to perform. It can be at the time the contract was made or when the contract has been made, the obligation became impossible to perform. For example, in the Taylor vs. Cadwell case, the plaintiff hired the defendant's hall for the purpose of performing concert. Nevertheless, the hall was accidentally burned down before the concert. The contract was discharged by frustration. In order for a contract to be frustrated, the following qualification must be satisfied. The event that caused the frustration must not be self-introduced. The performance of the contract must have been impossible and not merely more difficult or more expensive. The frustration event has substantially prevented the performance of contract as a whole. Circumstances in which contract may be discharged by frustration. Number 1, distortion of subject matter of contract. Number 2, supervening event defeat the whole purpose of object of the contract. Number 3, death or personal incapacity. Number 4, supervening illegally. And the last one, a declaration of war.
A contract is an agreement or promise made between two or more parties that the court will enforce. In some cases, the agreement and promise made in a contract are not kept by a party or more parties. Therefore, this situation called breach of contracts, which means failures to keep the promises or agreement of a contract. So, what is remedies? Remedies is a general term which means a right that can be claimed by a party to a contract that experienced losses because of the other party to the contract was in breach. There are several remedies for breach of contract, such as award of damages, specific performance and injunction or quantum merit. Let's move to the first remedy, which is damages. Damages given to a person in a contract who does not receive the right that he should from the contract. The aim of damages is to revert losses and damage because of the other party's breach. A person that claims damages must prove that the losses incurred because of the breach. The losses are commonly incurred and both parties expected the losses to incur if the contract is breached. For the example, we can look into Tam Chow Tong versus Associated Metals metal case. Next, damages divide by two categories, which is specific and unspecific amount. Damage of specific amount are damages by which the amount has already been agreed upon if there is a breach. It had been agreed when the contract is been made. The second one is unspecific amount, and it's divided by three classifications. The first one is substantial, which is a reward given is to put the plaintiff in a place that he should if defendant perform the contractual obligation. The second one is nominal, which is a small reward to a plaintiff after he show that there is a breach of contract, even though there is no real losses incurred. And the last one is exemplary. It is a reward that given a far higher than the losses incurred. The second remedy is specific performance. It is a discretionary remedy granted by the court. This means that a specific performance is a decree of the contract writing that the contract shall be performed specifically according to its term, that is 2. Circumstances under which specific performance may be granted by the court refer to Section 11(1) of the Specific Relief Act 1915, and the second one is circumstances when contract cannot be specifically enforced. Refer to Section 20 of the Specific Relief Act 1915. The last one in remedies is injunction or quantum merit. Injunction is a discretionary given by the court under Section 50, Specific Relief Act. An injunction may be of mandatory or interlocutory, an authoritative warning or order. For example, A wanted to sell his restaurant, so he offered his restaurant for Rm 600,000. And then B is interested with his restaurant and agree with the price given. Thus, A signs a contract with B for takeover his restaurant. After the contract has been signed, another buyer, which is C, is also interested with A's restaurant and willing to pay higher price. So A changed his mind and going to sell his restaurant to C. Based on this case, when B found out that A is going to sell his restaurant to C, B has the right to apply an injunction from the courts. It is because B and A have signed a contract before this. The contract will take action and stop A from selling his restaurant to C. The next one is quantum merit. What is quantum merit? It is a claim that can be made by a plaintiff who has performed obligation under a contract and then choose to rescind the contract after defendant's breach. Court will order a value that is adequate. So that's all from me and Julea. Thank you for watching our presentation. That's all from us. Thank you. Bye.